Ms. Sant, present in the courtroom with your attorney, Mr. Vogler. Mr. McLennan is here for the people. Mr. Vogler, have you had a chance to review the pre-sentence report and recommendations with your client?
I have.
Do you have any additions or corrections to the contents of that report?
I believe I have any.
Okay, and the advisory guidelines were scored at 0 to 11 months. Do you have any scoring challenges?
I do on that. That's a number of them, but I think if we cut to the chase, and they all concern PRV 5. The way I looked at the report, it appeared like there was a 10-year gap that would nullify any prior misdemeanors. Do that is to a 0 in PRV 5, and it reduces the guideline to 0 to 6.
All right, so let's back up here. Mr. McLennan, do you have any response to the 10-year gap objection to the prior record variables?
I did review it and I thought it was scored appropriately, Your Honor. I didn't see any issues, so.
Okay, well, let's just walk it back. We start with the most recent offense. 6 of 6 is a pending case in Alpena. That is that post dates the offense date for our case. Is that right? Okay, so that one doesn't matter to us. For a prior record variable, there's no conviction anyway. 5 of 6 is our case. 4 of 6. The offense date was February of 2023. The discharge date for 3 of 6 was 2011. So that would be in excess of 10-year gap. There'd be a 10-year gap between offenses 3 and 4. So nothing in 1, 2, and 3 would score. And
4 I think would be is basically taken up by this particular case. You wouldn't be able to score.
right, you don't score the predicate OWI offenses. So based upon that, I would agree with the defense objection and score prior record variable 5 at 0. That would bring the PRVs to 0, level to A. Range would be now 0 to 6. Any further scoring challenges from the defense?
No.
Mr. McLennan, any scoring challenges from the people?
No, Your Honor. There is one, I thought, correction that was needed in the
Okay.
report. That'd be on form CFJ-284, page 1. 4th paragraph down.
Okay.
The 3rd sentence of that.
What document is it?
Oh, it would be.
That's the, it's entitled pre-sentence investigations, the evaluation plan portion. Is that you're under the evaluation plan?
That's correct, Your Honor.
So the final paragraph under evaluation plan, 3rd sentence, what's your recommended change?
It says she has been attending AA meetings since October of 2025.
Well, that's got to be a typographical error then. What year should it be, do you think?
My guess would be 2024. I'm not sure though.
Miss, or I guess Mr. Vogel, you're planning to be in a better position to know the answer.
2022.
Okay, if we can make that change, Agent Lesky. All right, any other changes from the people?
Oh, Your Honor.
Any scoring challenges from the people?
Oh, Your Honor.
All right, Mr. Vogler, anything you want to say on behalf of your client?
Oh, yeah, sure. I would ask the court to follow the recommendation here. It's unfortunate that Ms. Sam was not able to participate in the sobriety drug program in Alpena. She was accepted. She went through all the application procedures almost literally a day or two before she was to be formally allowed into the program. She had in fact been attending the weekly court hearings, even though she wasn't actually in it. They cut the funding for that. But in terms of what she's done since this happened, she spent 70 days in jail here. She then completed 30 days at the Sunrise Center in Alpena. That was a prerequisite really to get into the Alpena sobriety court. She was successful there. She's got a job now and working that full time. Basically having to ride her bike into her job and stuff, but she's managing that. She does have still those cases in Alpena pending, and it's uncertain as to what will exactly happen there.
Ms. Samp, you don't have to say anything today, but you are allowed to. Is there anything you want to tell me? No.
I would, Your Honor.
Please go ahead.
I'm very saddened by how these line of events have gotten me to where I am. But in the same breath, I'm very grateful. I've struggled with sobriety through not only me, but my family, my entire life. And this is the first time in my life that I've genuinely embraced recovery. So I'm very grateful to be standing where I am right now. And I'm ready to face whatever consequences to my life.
All right, thank you. Mr. McClellan, any recommendations from the people?
Yes, Your Honor. This is Ms. Sam's third OWI. She has another OWI third pending in Alpena County. Background in this case, she was found in a rollover accident and then was intoxicated at the time. There's a public safety concern with that. She seems to have a problem. That's why we were really hoping for sobriety court outcome on this one. Additionally, while on bond for this case, she was being transported from the Alpena County Jail and did exit the patrol vehicle when it was pulled over and flee from the deputy, and he did have to apprehend her. Your Honor, I think given all the circumstances of this case, and this would be her first felony as far as the people are aware, some jail time would be appropriate.
Well, Mr. McClellan, I'm not sure that you're allowed to recommend jail. There was a sentence agreement for participation in a sobriety court program, which would typically not be jail. Are you withdrawing from that agreement? She'd be allowed to withdraw her plea. I mean, honestly should be allowed to withdraw her plea today anyway, because she can't receive the sobriety court that she bargained for. My intention is to give a probation only sentence. I agree with Mr. McClellan. Absent that agreement, this would be the kind of thing I'd be looking at some jail. But to follow that agreement, I would give a probationary sentence. My understanding would be if I didn't do so, she'd be allowed to withdraw her plea today. Mr. Vogler, I guess, is she seeking to withdraw her plea if I impose a probationary sentence?
She's not.
All right, well, Ms. Samp, I'm glad if you are now, I guess, awakened to the situation that you're in. You know, this involved a single vehicle crash. You could have been hurt or killed. You could have hurt or killed somebody else. Sounds like you've got good employment. You know, looking at your criminal history, it doesn't sound like you're somebody that wants to go out there causing chaos and harm to people in the community. But if you're driving drunk, I mean, I've said this to other people. Aside from that, you don't strike me as a particularly dangerous person. But when you're behind the wheel of a car and you're impaired, you're a very dangerous person. And you probably don't want to be a dangerous person to the community. You drink and drive, you are. You're just as dangerous as somebody out there with a gun and bad intentions. And it sounds like getting your attention has been maybe not the easiest thing to happen. Should have happened the first time you got arrested for drunk driving. Definitely should have happened the second time, which by the third time is considered a felony. Now you'll have a felony adjudication on your record. It's not a, no kid grows up and says, gee, I want to be a felon when I grow up. It's not a great thing to have in your record. and you've got the pending case in Alpena. You may end up getting some incarceration for that. I don't know. I think it's a shame that that treatment court didn't work out for you. I think you'd be a good candidate for that. You know, despite you not being able to do that, I would look to impose some jail. You already did 60 days, so I'm not going to impose any additional time. That does meet the mandatory minimum under the statute as well. So I'm going to follow the recommendations of the Department of Corrections and place you on probation for 18 months. That's subject to the terms and conditions listed on the pre-sentence report on pages 2 to 3. I want to highlight some of those requirements. You have to comply with all of them. I'm just going to highlight some for you. You have to attend AA, NA, or meetings, you know, structured support group meetings as required by your agent. You have to complete a substance abuse assessment and complete any treatment when referred by your agent. You have to complete any counseling or mental health treatment that the agent refers you to. You do have to perform 60 days of community service. That's a hefty community service for the drunk driving third, so you got to get on that. You have to maintain legitimate full-time employment. I'll order 60 days jail with credit for 60 days served. There's an OWI reimbursement of $100, crime victims assessment of $130, court costs of $350, fine of $500, DNA testing with a $60 fee, $68 in state cost, and there's a monthly supervision fee to the Department of Corrections. If you can't pay that immediately, you'll have to set up a payment plan with the clerk's office. And that this is a sentence within the advisory guidelines, and it's trying to follow the spirit of the sentence agreement. I think it's proportionate to the seriousness of the circumstances of the offender and the offense. And Ms. Samp, if you want to appeal, well, first off, you are eligible for early discharge from probation at the halfway point if you've successfully completed all the terms of probation. So we're going to hand you a piece of paper explaining that process. You also can file an application for appeal. We're going to hand you a piece of paper explaining your appeal rights. If you want a lawyer, you have to ask me within 6 months. We're going to ask you to initial one copy of the appeal rights form, and the other one is for you to fill out if you want to take an appeal. Do you have any questions for me?
No, you're on.
Agent Lesky, do you want her to stick around to talk with you?
Yes, please.
If you want to stick around in the hallway and talk to Agent Lesky before you go there. Okay.
Thank you.
There was a bond posted? Was that posted by? Was the bond posted by you?
No.
Who posted that?
My mother did, but I don't think she did it in her name. I think she put it under my name.
Okay. Do you know is she here today?
No, we don't speak any longer.
Okay. And was that posted in? It shows under your name. It shows under the Samp's name. Okay. Well, because it's posted under your name. Oh, there's. Yeah. All right. So this is. Are you Tracy Straight?
Yes, I am, Your Honor.
Okay. Good afternoon. Counsel, you want to state your appearances, please?
Anthony Children.
Liz Elliott on behalf of Tracy Straight.
All right, and we scheduled this for a competency hearing. Ms. Straight has previously been held by this court to be incompetent to stand trial and was sent for treatment. I received a report by Dr. Gren dated 8/8/2025, indicating that the opinion that from the forensic center that she has been restored to competency. So we scheduled this for a competency hearing within the statutory time frame. Do the people have any objection to the court's receipt and consideration of the report?
No, Your Honor.
Does the defense?
No, Your Honor.
Are there any additional proofs on the question from the people?
No.
Any additional proofs on the question from the defense?
No.
And based upon that, I would find that Ms. Straight is competent to stand trial and the case shall continue to the next stage of the criminal process. It did appear based upon the report that she is receiving medication to maintain competency, so I will check the box on the state form indicating that the defendant, in order to maintain competency to stand trial, shall be administered appropriate medication pending and during a trial. So I guess then that brings us, we need to schedule this for a docket call, probably in September. Set it for September 30th at 2:10 p.m. And Mr. Juliet, do you know then, what happens logistically then? Is she going to remain at the hospital pending that, or is she going to need to be returned to the Sheboygan County Jail?
It's my understanding she's going to need to be returned.
Okay. All right. Anything on that from the defense?
Well, Your Honor, in speaking with Ms. Straight, she mentioned something called a maintenance order that would allow her to stay at the forensic center pending trial. And I am imagining that would be so that she can continue with her therapy and continue to receive the medication she needs to maintain competency. So we would ask that the court would order that. If the court's not inclined to order that and she's transported back, we would be asking that Ms. Straight be placed on a tether if the court's concerned for her risk of failing to appear. A tether could assure the court that she will appear when she's directed to. She has a mother who's in very poor health, and she would like to be able to get back here and see her.
Well, I mean, I think she's been committed for treatment to see if competency could be restored. There are statutory limits to the time that she can be under that order, because it's not really a mental health treatment order through the probate court where she would have all sorts of rights to review. So just looking at the applicable statutes, let's see, redeterminate.
And excuse me, Your Honor, this is Ashley Kelly, court liaison here at Walter P. Ruther. May I interject?
Yes, please.
Yes, so you are totally correct. Here at Walter Ruther, we have patients here until they are restored competent. And just as in Ms. Straight's case, once she is deemed competent, we obtain the finding and order on competency, and then she will be returned to jail.
Okay. Yeah, that's what I thought. I'm looking at the statutes. There's a limit to how long, because she's being held at that hospital involuntarily. I understand she's saying now maybe she'd like more treatment, but she was sent there involuntarily based upon my authority under the mental health code for incompetence to stand trial. Now that she has been found competent, I don't think that my order allows that treatment to continue there. The hospital, if they saw fit, have statutory authority to petition for treatment. They're probably not going to do that. The prosecutor's office or family members would have authority to petition for treatment upon Ms. Straight's return to the jail. If she wants to seek voluntary mental health treatment, I'm sure the jail can facilitate, an assessment for the needs and appropriateness of that. In this case, her bond had been revoked for an absconding from the felony bond. So I'm not going to reinstate the bond at this time, just to have a hospital downstate cut her loose, and who knows how she can get back. We'll have the sheriff's department go and retrieve her, return her to our jurisdiction, and then we'll have the docket call on September 30th. In the meantime, as soon as she's returned, if the defense wants to file any motions prior to the 30th to review either the bond or any treatment needs, you can certainly notice up any such motion. Okay. All right, thank you, ma'am, for that clarification as well.
All right, thank you. And then can you guys, once that finding an order is established, can you please send a copy over to Walter Ruther? Because that is our documents to be able to release her to the sheriff.
Okay, very good. Very good.
Right.
We'll do that.
Okay, thank you.
Thank you.
Is there a chance that I could speak with my attorney before we're exited out?
Well, I could do a breakout room but your attorney on the underlying case is Mr. Gilbert, and he could not be here today, and Miss Elliott is assisting just for today. Did you want to speak with Miss Elliott, or you want to talk to Mr.
Yes.
Gilbert?
I would like to speak with Miss Elliott.
Do you have other matters
I
downstairs?
do, they're doing arraignments in district court right now. So.
All right, Miss Elliott is her attendance is required in another court right now, so we're not able to do that. She can see if she or Mr. Gilbert are able to talk to you down there, but you should pretty shortly be brought back up here